Right. I think we'll make a start. Good afternoon, everyone. For those who don't know me, I'm Hari Menon. I'm from Park Lane, Plowden Chambers. I'm going to deliver this talk on marital and civil partnership discrimination, which is, in the scheme of things, a relatively unusual topic in the field of discrimination, not least because it is relatively rare. So what I'm going to say covers both marriage and civil partnership discrimination. So any reference to marriage in the course of this talk is intended to refer also to civil partnerships. Now, just a few preliminaries. The first is that I'm working from two screens, so if I appear to look elsewhere, it's not because I've lost interest in this talk, it's because I'm looking at the screen to my right. Secondly, this talk is not about ordinary unfair dismissal. It's related to dismissal in the context of marital discrimination, and it is usually direct marital discrimination, because the cases on Section 19 indirect marital discrimination are quite rare. The next point to bear in mind is that there is no Section 15 or Section 20 Equality Act equivalent to marital discrimination. So, for example, you cannot discriminate against somebody for a reason arising out of being married or being in a civil partnership. So the choices really for marital discrimination are direct discrimination and indirect discrimination, so sections 13 and 19. Now, I hope that all of you will have, in some form, electronic or otherwise, because my chambers has sent these out, you will have the PowerPoint together with the handout. So my talk will be principally in relation to the PowerPoint, and you can consult the handout as and when needed. So one thing to note about marital discrimination on the authorities is that it appears to be relatively difficult to do. And in that sense, it is much more difficult to perpetrate than other species of discrimination. And we'll see shortly why that is. So we begin with the latest case on the subject, which is the case of Ellis and Bacon, which was published on the EAT website last year, and the decision was handed down on the 22nd of November. I think it appeared in Daniel Barnett, maybe first or second week of January. So as far as I'm aware, this is the latest on the subject. So in short, the position is this, that Mr. and Mrs. Bacon were directors and shareholders of the respondent company, that the second respondent company. The villain of the piece for the purposes of this case was Mr. Ellis, the managing director and the first respondent. Now, the company did not take part in the proceedings other than being named a party, because it was in liquidation, and that straight away means that there was no claim for ordinary unfair dismissal, or none that was pursued, because there was a claim, but it wasn't pursued. So the only claim that was live was the claim for marital discrimination against Mr. Ellis, which arose in these circumstances that Mr. and Mrs. Bacon had a falling out, the marriage broke up. Mr. Ellis took the side of Mr. Bacon and subjected Mrs. Bacon to adverse treatment, culminating in dismissal. Now, the Employment Tribunal found for Mrs. Bacon on marital dismissal, on marital discrimination. And Mr. Ellis's appeal to the EAT succeeded. And the EAT's reason was that Mrs. Bacon's treatment, adverse though it was, and remember, had the ordinary unfair dismissal been live, Mrs. Bacon would have walked it. But as it turned out, it wasn't. So the reasoning was that Mrs. Bacon's treatment, although adverse, was because she was in a close relationship with Mr. Bacon and not arising out of the fact that she was married to him. And the EAT, I think it was Judge Shanks, who said that marital discrimination is not where a claimant is discriminated against because of the fact that she is married. So in order for there to be marital discrimination, the EAT said on this occasion that it does not apply when your complaint is that you're married to a particular person, right? So if by sheer bad luck, you happen to be married to the wrong inverted commas person and you're dismissed because of that, you don't have a claim for marital discrimination. And in so holding, the Employment Appeal Tribunal said that they were following the case of Hawkins against Atex Group, which was decided some years ago. But before we get to Hawkins, let's have a slight segue and look at two other cases which will be relevant to what we have to consider shortly. The first is a case that all of you will know of, Shamoon against the Chief Constable of the RUC, where the House of Lords said that in the case of direct discrimination, it is better to, as it were, postpone the issue of less favorable treatment until you've decided, until the tribunal has decided that why the treatment was directed at the particular claimant. So House of Lords said, look at the reason why. Just park the question of less favorable treatment, look at the reason why. And an illustration of this is the case of High Quality Lifestyle against Watts. Although this was a decision of the EAT, and it did not explicitly make any reference to the case of Shamoon. What it actually did is adopt the reason why test. So in this case, the claimant was suspended and subsequently dismissed after it was found out that he was HIV positive. Now, the employer provided services by way of care for autistic and autistic persons and for those with learning disabilities. And what Mr. Watts claimed was that he was being directly discriminated against, disability discrimination, because he was HIV. Now, although he succeeded at first instance, the Employment Appeal Tribunal allowed the appeal, and they said that what Mr. Watts was dismissed for, the reason why, was because of the risk of transmission of HIV to the service users who were vulnerable. And this was a case in which carers in Mr. Watts's position were prone to get cuts and bruises because of untoward incidents with the persons to whom care was being given. So that was the reason. And the reason why was not simply because he had a disability by way of HIV. So just bear this in mind when we move on or move back to marital discrimination. So now the case of Hawkins against ATEX Group, which was purportedly relied upon in Ellis and Bacon. So the facts are that Mrs. Hawkins was married to the CEO of the company which employed her. Both she and her daughter were appointed to senior positions within the company, and that was in breach of an express direction by the chairman to the CEO that he should not employ members of his family within the company. And the express reason given was to avoid any appearance of a conflict of interest or nepotism. So the company wanted to convey the image that everything was above board and that it wasn't a kind of corrupt family business. Now, the claim was struck out by the employment tribunal on the application of the respondent, because the respondent said, marital discrimination cannot apply to a case in which you are complaining because of adverse treatment on the grounds that you're married to a particular person. Okay, so what the EAT did was it dismissed Mrs. Hawkins' appeal and said this by way of reasoning, and I summarize. It said that if the claim was based on marriage and the identity of the spouse, it can only succeed if the fact of the marriage, as opposed to a close relationship, was part of the grounds for the employer's reason. And it said, secondly, that the correct comparator in such a situation would be someone in a relationship akin to marriage, but not married, and applies equally to civil partnerships. And they said in this particular case, the dismissal was not motivated by marriage, but by the closeness of the relationship between Mrs. Hawkins and her husband, the CEO, right? Now, I think that this reasoning has got certain problems, which is this. Now, the notion that the dismissal was because of the closeness of the relationship and not specifically because of the marriage cannot stand up, because the chairman's explicit reason, relied upon by both the Employment Tribunal and the Employment Appeal Tribunal, was that the CEO should not employ members of his family. So in Mrs. Hawkins' context, family can only mean marriage. Incidentally, both Mrs. Hawkins and her daughter were dismissed. Now, obviously, the daughter won't have any grounds to bring a claim based on marital discrimination. But in Mrs. Hawkins' case, she could say that this was because of my marriage, simply because that was what the employer said. In effect, you can't said to the CEO, don't employ anyone within your family. However, that's a defect in reasoning, but I think that the result was correct, because if you apply the reason why wasn't because Mrs. Hawkins was married to the CEO, it was because the company wanted to have an image that it was completely above board, there were no conflicts of interest or any nepotism. So that's an application of Shamoon and high equality lifestyles against Watts. Now, I mean, I haven't been to the whole of Hansard to pour through the debates on the Single Equalities Bill, which later became the Equality Act 2010. But there is a passage in the government response, which you will see on slide number 5, and I think you will see it also in your handout on page 4. There's the government response to marital discrimination. Now, although this response is in the context of indirect discrimination, it appears tolerably clear that the government at the time did not intend marital discrimination to be an obstacle to dismissals of this kind, where there were restrictions on people in relationships, including marriage, working together. Okay, so we then just look very briefly at 4 cases on the issue of marital discrimination, because they've got, each of them has got its own features and its own kinks. So we start off with the case of HORSEY, which is a very old case in 1982. And what happened there was that Mrs. HORSEY worked for DYFED Council, and she was doing a course, but managed to get an offer of a secondment to the same course in Kent. And Mrs. HORSEY's husband had obtained a permanent job as a librarian in London. Her request for the secondment to Kent was refused by the council because it believed that she would not return to work in Wales if she was seconded, but she would want to remain in the south of England or in London with her husband. And Mrs. HORSEY's claim for direct and sex and marital discrimination under the 1975 Sex Discrimination Act was dismissed by the Employment Tribunal. Incidentally, you will find the relevant acts, relevant statutory provisions, Section 8 of the Equality Act and Section 3 of the Sex Discrimination Act, as it was immediately before the Equality Act was enacted, on page 1 of the handout. Right, so when this matter went to the EAT, what happened was that the Employment Tribunal allowed the appeal on direct sex discrimination. It held that the council had engaged in a stereotypical assumption that women would follow their husbands, because it pointed to the fact that on previous occasions, when Mrs. HORSEY had been sent on courses or was doing a course elsewhere, her husband had actually followed her. So they said that a stereotypical assumption was direct sex discrimination, and it was not necessarily to consider the marital discrimination point, which is a bit of a shame, because it would have been interesting to see how they would have dealt with that. An interesting feature in this case, which is mentioned in the report, but for some reason wasn't plugged by the council, was that the permanent librarian job that Mr. HORSEY managed to obtain in London was in the House of Commons Library. So he got a plum job, and it was a reasonable assumption that he was not going to give it up anytime soon. So that point appears to have evaded everyone, and it might have evaded the tribunals because the employer didn't seek to make all that much of it. Moving on, another case, the Chief Constable of Bedfordshire and Graham in 2002, where Mrs. Graham was appointed as an area inspector, and shortly thereafter that appointment was rescinded. The Chief Constable's reason was that Mrs. Graham's divisional commander was her husband, and that he was, as the law stood then and as it stands now, the Chief Constable believed that the husband would not be a competent or compellable witness for the prosecution against Mrs. Graham and vice versa. Okay, so in that belief, the Chief Constable got it wrong, because spouses are competent but not compellable. That was a law then, that's still the law now. Okay, but in the scheme of things, that mistake didn't matter. So the Employment Tribunal upheld Mrs. Graham's complaint, or Inspector Graham's complaint, of direct and indirect marital discrimination. The Chief Constable appealed, but his appeal was dismissed. And the EAT's reasoning was this, that on direct marital discrimination, rescinding of the claimant's appointment was based on the fact of the claimant's marriage, as opposed to the marriage to a particular person. And it's important to note that this is how the EAT reasoned. They said, this is not particular husband discrimination, this is marriage discrimination. And that was clear marriage discrimination because of the rule relied upon by the Chief Constable, which was the lack of compellability of a spouse. Now, it also found that it was indirect marital discrimination because of the proportion of married officers of the same sex who could comply with the condition not to work together was significantly less than the unmarried officers in a relationship with another officer. Now, that point, that indirect marital discrimination point, is less controversial because it was based on statistics which were clearly borne out. Now, what is more problematic is the reasoning about direct discrimination. So the assertion that this was simply a marriage-specific case as opposed to a particular spouse case, it seems to me can't be right. So Mrs. Graham's appointment was not rescinded just because she happened to be married. It wasn't rescinded because she wasn't a single person. It was because she was married to somebody else in the chain of command, and in particular, a divisional commander. So this was prima facie direct marital discrimination. For example, if you look at Hawkins, the EAT said that Mrs. Hawkins would not have been dismissed had her husband not been the CEO. So by parity of reasoning, applying the same reasoning here, the case of Graham was wrong on that point. However, in the result, if the reason why test is adopted, it seems to me that the case for marital discrimination could not be made out because, by analogy with high quality and lifestyle against Watts, the reason her point was rescinded was because the non-compellability of a witness against her husband and the other way around could undermine the integrity and objectivity of the force. So that was it seems to me, was a good reason for not allowing the claim based on marital discrimination, or at any rate, not allowing the direct discrimination claim. Then we move on to the cheerfully titled Dunn against Institute of Cemetery and Crematorium Management, where Mrs. Dunn claimed that she was constructively dismissed because of treatment which arose from the deteriorating relationship between her husband, who was also an employee, and her employer. Now, her claim for marital discrimination was dismissed by the Employment Tribunal, and she appealed successfully to the EAT, which was the late Judge McMullen, which decided as follows. First, it says that marital discrimination did extend to discrimination because of a particular spouse. And curiously, it said that Graham, the case of Graham, was the authority for discrimination applying to a marriage to a specific person, although that's not what Graham actually says. The trouble with Graham is that it says one thing and does something else. And then thirdly, the EAT said, by treating the claimant as they did because of the relationship with the husband, the employers were treating her as an adjunct of her family. And this is an important point, because in a lot of these cases, you can imagine a scenario where wife who is blameless is dismissed because of some infraction or wrongdoing by the husband. We'll come back to that in a minute. And Dunn, for the first time that I've seen, raised the Convention of Human Rights and says Article 8, 12, and 14. So Article 8 is, just give me a moment, is, yes, the respect for private and family life. Article 12 is the right to marry, and Article 12 is the prohibition of discrimination on grounds of status, which includes marital status. So what Judge McMullen said was that had he been required to find make a finding on convention rights, he would have found for the claimant on the basis of Articles 8 and 14, not so much 12, because the marital discrimination provisions had to be applied to give effect to convention rights. And his argument, or his other argument, was that a claimant can properly be heard to say that their right to marry a particular spouse could not be undermined ex post facto by treatment by her employer, which includes, but it's not limited to, dismissal. So if you recall, I'd mentioned the case of Hawkins, and in Hawkins, Dunn was criticized because there was a fundamental disagreement on what the expression marriage specific meant. For Hawkins, marriage specific meant the status of being married. And in Dunn, it was a more expansive view. Also, the convention rights were raised in Dunn, but not addressed in Hawkins. So this is something which may need to be looked at in subsequent cases on the subject, if and when they get to the EAT. The last case is the case of the Reverend Gould against the trustees of Devonshire Hill. And the Reverend Gould was the vicar of the church. He was dismissed. He said, because he had marital difficulties which the trustees disapproved of. Now, the trustees, for their part, said that this was just a breakdown in relationships and it's got nothing to do with marriage. And the trustees applied to have the claim struck out on the basis that there was no cause of action disclosed. Now, the employment tribunal agreed with the trustees and struck out the claim, but the Reverend Gould's appeal was allowed. So what the Employment Appeal Tribunal said was that the fact of being married need not be the only or main reason for the treatment complained of. If the fact of the claimant's marriage plays an operative part in the reason or reasons for the treatment, the statutory protection applies. Now, operative part, okay? So, so how does Gould help in resolving uncertainty about when marital discrimination applies? Well, it assists to the extent that it does not seek to tie marital discrimination only to the status of being married. There can be reasons other than pure marital status which triggers the statutory protection, as long as that reason is linked to the status of the claimant as a married person. However, you have to bear in mind the facts in Gould was that this was a church which took the institution of marriage seriously. So it was therefore, in the context of this case, that much easier to assert a link between the mere fact that the claimant was married and the matter being complained of. So this was an unusual case. And Gould, in common with other cases, is unhelpful because, in my view, it gets the matter of the comparator wrong. What Gould says that in this case, the proper comparator, because there was an exchange between Mrs. Justice Simler, who was a judge, and counsel for the respondent. And the counsel for the respondent maintained that the proper comparator is not a single person who has relationship difficulties in a long-standing common law spousal relationship. So counsel for the church was for saying that the proper comparator was not an unmarried person in a close relationship or a cohabitee of long-standing. Now, Mr. Justice Simler rejected that, but what I think the Employment Appeal Tribunal overlooked was that the comparator that it chose could never exist in the context of this case, because this was a church. And had the trustees known that the Reverend Gould was in a common law relationship with somebody and cohabiting with someone who was not married, he wouldn't have got through the doors of the church. So this is one of these cases in which no comparator, it seems to me, is possible. Note also that in the case of Graham, I don't think any comparator is possible, because the the only reason why the appointment of the claimant in Graham was rescinded was because, as a matter of law, a spouse is not a compellable witness against the other spouse. And you cannot construct a comparator. That is a unique legal relationship which is not capable of being duplicated elsewhere, even by means of a hypothetical comparator. Okay. So, conclusions, where do we get to? Well, it seems to me that the real issue is not an argument about whether marital discrimination is only related to the status of being married, or whether it can extend to marriage to a particular spouse. That seems to me to be a bit of a non-question, because it clearly can apply to both. But marital discrimination is a statutory tort that is going to be difficult to prove because of two things. The first is the Equality Act comparator, section 23, because in the vast majority of cases, it will be relatively easy for the employer to come up with a comparator, somebody in a close relationship akin to marriage, who would have been dismissed or treated in the same way. I'll give you an example. I mean, let's say you've got two employees in a solicitor's firm, and one of them is caught misappropriating clients' funds. The other spouse is completely innocent, and the employer dismisses the guilty spouse and later says to the non-guilty spouse, "I'm dismissing you as well, because our firm cannot afford an association with somebody who's been guilty of fraud and perpetrated a fraud on clients. So, sorry, we are dismissing you SOSR." Okay, so can that be marital discrimination? Well, what the employer will say is, the fact that they were married is neither here nor there. We would have dismissed the innocent spouse, even if they weren't married, but had been in a close long-term relationship and still were, right? Now, what we have to bear in mind is this: the reason advanced by the employer doesn't have to be a good one. It only has to be a genuine one, right? It could be irrational, it could be unfair. But whilst that is a question for ordinary unfair dismissal, it is not a question for direct discrimination. For direct discrimination, all you need to have is a genuine reason which is non-discriminatory, right? So, I mean, obviously, the more irrational and the more, out of left field a reason is, the more likely it is to be regarded as a sham. So that's the risk that employers take if they run defenses which are viewed as being objectively unreasonable. But that's not a prerequisite, right? To have a rational reason is not a prerequisite legally. So you can always construct, I mean, save for cases like Graham and Gould, an employer can always construct a close relationship hypothetical comparator at least, right, to get out of marital discrimination. And the other reason why it is difficult to prove marital discrimination is that there are relatively few scenarios in which the adverse treatment can be said to be limited to the fact of the claimant's marriage. I mean, you can have an employer who's particularly crass, who say things, who might say something like, we don't promote married women, right? So that would be a case of direct marital discrimination. But how many cases would that happen? So, and Hawkins is a particular illustration of this, because marriage was something which provided the occasion for the treatment without being the reason for it. So marital discrimination, I mean, it's on the books. It does, there are cases in which claimants can succeed, but this is a statutory tort, which is perhaps the most difficult of the protected status cases to succeed in. Right. Now, that is the end of my talk. Now, unfortunately, in this format, it is not interactive, I'm afraid, and we are trying to do something about it. So what we will do for future talks is to have a more interactive format. Now, if you have any questions, you can see a Q&A tab. Hopefully you can. And if you've got any questions, if you type your questions in that, I'll see what I can do. At the minute, I don't have any. And I'll just wait a few minutes for anyone who does have any questions. And if you do, just let me know what they are. Right. Now, Victoria from Chambers is very helpfully sitting in with me in the background in case of any IT fumbles. So if there are any questions popping up, she will no doubt let me know. Right. Oh, there appears to be something. Right, James English has asked whether I have dealt with any live cases. Short answer is no, I haven't. I fear that my knowledge of this area, such as it is purely theoretical, right? I shall just send the answer to James as well. And anyone else? Right. Now, in the absence of any further queries, then what I will do is say good afternoon and enjoy the rest of your lunch. All right. Thank you very much.